What happens when a public school curriculum collides with the deeply held religious beliefs of parents? In the 2025 Supreme Court case Mahmoud versus Taylor, the Supreme Court justices were asked to answer just that. At the heart of the case, LGBTQ plus inclusive storybooks were introduced into an elementary school curriculum in Maryland. The school initially offered parents the option to opt their children out of those lessons, but later reversed course, mandating participation. That decision sparked a legal battle. A group of parents, practicing Muslims and Christians, argued that the mandatory exposure to these materials violated their constitutional right to raise their children in accordance with their religious beliefs. They weren't objecting to the existence of the books, but to being denied the choice to opt out. The books themselves were central to the case. Titles like Prince and Knight and Born Ready weren't just educational. The court found they presented clear moral viewpoints, views that encouraged affirmation of same-sex relationships and gender transitions. The Supreme Court agreed with the parents. In a landmark opinion, the court emphasized that while public schools have a duty to promote inclusion, they also have a constitutional obligation to respect the religious freedom of families. Relying heavily on the precedent set in Wisconsin v. Yoder, the court held that the no opt-out policy posed a real and substantial threat to the parents' ability to guide their children's religious upbringing. They rejected the argument that Yoder was uniquely about the Amish, saying its principles apply more broadly. In contrast, the school board claimed that merely exposing students to diverse ideas was part of fostering tolerance, but the court found that this wasn't neutral exposure. It was a normative presentation, reinforced by teacher guidance, in a setting where students were expected to accept and internalize the values. The court also pushed back on comparisons to other religious freedom cases like Bowen v. Roy, noting that what happens in a Social Security office is not the same as what happens in a first-grade classroom. The result? The court issued a preliminary injunction, requiring the school board to notify parents in advance when such storybooks will be used and to allow children to opt out while appeals continue. The dissenting justices warned that the ruling opens the door to unmanageable complexity in school systems, arguing it could lead to censorship, chaos, and endless litigation. Still, the majority held firm. Public education cannot be conditioned on the surrender of religious conscience. The implications of Mahmoud versus Taylor go far beyond one school district. It marks a major moment in the ongoing national conversation around parental rights, religious freedom, and public education.